Mr. Brown, you look poised maybe to get a witness. Okay.
We are going to call Dr. Kruse, Your Honor. One thing we neglected to do earlier this morning, which we should have done, is to give the court the file of all of our exhibits, Your Honor.
Right, thank you. Good morning, Dr. Kruse. You've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
Yes.
Okay. Go ahead and have a seat, please.
Thank you.
Ms. Thompson?
Thank you, Your Honor.
Whenever you're ready.
Good morning, Dr. Kruse.
Good morning.
We have not met, but my name is Tara Thompson. I'm one of the attorneys for Todd Mullis in this case.
Okay.
Could you please state your full name for the record?
My name is Kelly Kruse. It's Kellylykrusse.
I may be the only person that's having this problem. I'm criminal control here.
Sure, and I can't see.
I'm sorry, there's no light on it, but
If you'd hit the, yeah, perfect.
okay.
And Ms. Thompson, your microphone's not on either. There we go. That might help.
Thank you, Your Honor. All right, with that out of the way, Dr. Kruse, you gave testimony in Todd Mullis' trial, criminal trial back in 2019, correct?
Correct.
And at that trial, you testified about the autopsy that you performed on Miss Amy Mullis back in 2018, right?
Correct.
And you prepared a report based on the autopsy that you conducted?
Correct.
In your trial testimony at Todd's criminal trial, you gave your opinions about the cause and the manner of Miss Mullis' death?
Correct.
And at that proceeding, you testified that the manner of her death was a homicide?
Correct.
And you testified that it was your opinion that someone struck her with a corn rake and that killed her?
I testified that she had injuries that would be consistent with those caused by the corn rake.
Was someone striking her with the corn rake and that causing her death?
Correct.
Those are opinions that you maintain today, Dr. Kruse, is that right?
Correct.
And you're not here at these proceedings to offer different opinions than the opinions that you've already given in your prior report and your prior testimony?
Correct.
You reached your opinions about the cause and the manner of Miss Mullis' death at the autopsy that you performed on November 12th of 2018. Is that right?
Yes.
And you based your conclusions about the cause and the manner of her death on what you learned at that autopsy, right?
Yes.
Is there any disagreement in your mind or any confusion in your mind that Miss Mullis was found with something called a corn rake that had been impaled in her back and her side?
That's information that has been consistent, so I don't have any reason to not believe that.
And it's also your understanding that after that occurred that she was rushed to the hospital, right?
Yes.
And that it was her husband Todd and her son Tristan who took her to the hospital?
That's what I've been told, yes.
And it's your understanding that they got partway down the road to the hospital when they were met by emergency medical services, people who performed resuscitative efforts on Miss Mullis?
Yes.
And then it's those EMTs that then took Miss Mullis to the hospital?
Yes.
And she died at the hospital at 1:08 a.m.?
I'd have to check the time.
And sorry, I misspoke. She died at the hospital at 1:08 p.m., correct?
I would still like to check the time, but she died at the hospital.
Well, she died at the hospital.
Correct.
After she passed at the hospital, the medical examiner that was covering Delaware County at that time, Dr. Craig Thompson, he called your office?
Yes.
And he told you that he was sending Miss Mullis's body to your office for an autopsy?
Judge, I'm not object. These questions are all leading.
They are. Yes, I appreciate Ms. Thompson moving things along, if that's her intention in using leading questions. But since there's been an objection, if you could rephrase and avoid using the leading questions.
Your Honor, this was the subject of the pretrial motion that the applicant filed, and I do want to be heard on this issue. We filed a pretrial motion about this exact issue. We can take it up at sidebar or with the witness, but we filed a motion about this issue.
Okay.
It's just background information anyway.
Did you want to take it up in a sidebar or just take it up on the record? Obviously, I assume you're referring to the issue of this witness being taken out of order.
No, Your Honor.
Oh.
Yes, I apologize because I truly thought this issue was resolved.
Okay. I guess I'll leave it up to you if you'd prefer to take it up in a sidebar or just on the record now.
I don't think it impacts the content of the witness's testimony, so I'm fine for the witness to remain.
Okay.
The motion that we filed addressed a couple of issues. One, that this witness is an agent of the state, and as such, under the rules, I'm allowed to cross-examine her because she's not a hostile person with respect to the witness, but she's hostile for purposes of the rules. This is also relevant to the burden that Mr. Mullis has to prove at this hearing about what her testimony, what the trial would have been like with additional information, and she would have been the state's witness at trial, and she would have been cross-examined by trial counsel. So a cross-examination is appropriate regardless of who is proffering the witness. We certainly are proffering this witness. But the issue of her being an agent of the state alone makes it appropriate for me to lead her.
Any response, Mr.
Judge,
Brown?
this is a witness they're calling regardless of what her position was at the previous trial. These are leading questions. Developing an issue and asking leading questions in some respect is fine, but we're going to be getting into other details relating to Dr. Kruse's opinion. They're calling her as a witness. I think they should be made to follow the rules of evidence, so that's why we're objecting.
Yeah, this is a different situation. I don't think there's been an issue of establishing Dr. Kruse as a hostile witness in any sense. As far as her being an agent of the state, counsel, if you want to lay some foundation to establish, again, that agency relationship, something that would support or demonstrate a rationale for treating her as a hostile witness, you may do so. But for now, let's proceed as if she's your witness.
We should approach the side.
Your Honor, I'd like to lay some foundation for this issue, but it was my understanding that this was addressed in our motion and that this had been ruled upon. So I don't want to, this is an important issue for us, and that's why we briefed this issue and cited law and cited the statute, which says that a witness that's identified with an adverse party may be treated as hostile. And again, it's not about, obviously, Dr. Kruse's conduct on the stand, but her identity as the person that she is. I'll ask some questions on this topic, but this is an issue that for Mr. Mullis is important, and that's why we filed the motion that we filed. And we also discussed this at the pretrial conference, Your Honor, which is why, again, I apologize. When we addressed the issue of how the witnesses were going to proceed, it was my understanding this issue had been resolved.
Certainly. And I understand that there was discussion about calling witnesses out of order. And I think that there was clarity in that regard. I don't recall a specific discussion about this particular issue. And I certainly could be wrong. Counsel, maybe you want to chime in here.
If I may, Your Honor, certainly Rule 5.611 sub C for leading questions would not permit them normally on direct examination. And we have hotly contested, I believe, as the court knows, whether or not Dr. Kruse is in fact an agent of the state, because the state for this purposes under Iowa's PCR Act is the Attorney General's office and the criminal justice section. Most of the witnesses, if not all of them, would have been, in their concept, then a hostile witness and would fall under too broad a scope. Certainly, Dr. Kruse has been openly answering the questions and trying to be responsive to them, and certainly there should be no reason to believe she's hostile yet. Now, should a finding of hostility be found later on, then maybe this could change, but the court has no reason to grant that right now, as she is not associated or called by us at this point in time, and the court's pretrial ruling was not in reference to this as it related to the pretrial motions. So the state would resist that finding.
Your Honor, our motion on this topic is at D0290.
Did you say 290?
Is that correct? Yeah,
From-
D0290.
From 20. That's the motion to admit deposition testimony, yes?
It addresses other topics as well, which includes being able to lead this witness.
And Your Honor, again, I don't believe that the court ruled on that, and that wasn't pertinent to this at this point in time either.
Since it is just about noon, I think probably the prudent thing to do is take our lunch recess. We will excuse the witness for now. We'll pick up any additional argument on this issue that we need to over the noon hour, and then pick back up with the witness's testimony once it's been resolved and everybody knows where things stand. Dr. Kruse, you may step down. Let's plan on resuming at 1:15. Counsel, if you can, well, why don't we take care of this right now? If that works for you?
Yes,
Okay. Ms. Thompson, any additional argument that you would like to make?
Well, two things, Your Honor. One is, Rule 5.611 is very clear that the issue about leading questions is not just about, I mean, we all understand the classic witness who isn't cooperating in the exam, but that's not what Rule 5.611 speaks to. It speaks to, and literally says, the court should allow leading questions when a party calls a witness identified with an adverse party. And that is also, as we cited in our motion, what Iowa Code 624.1 says, which allows parties to call agents of public corporations and to treat them as, you know, they are a representative of the adverse party. And we can lay some foundation for this, but it's really undisputed that this witness is an employee of the state of Iowa. There is evidence in the record that she was being advised by Scott Brown as to her conduct in the pre-trial litigation of this post-conviction matter, taking advice and direction from the Attorney General's office about how to respond to the issues in this case. there's no question that she's identified with an adverse party, and so it's not about whether she responds to the questions in an appropriate way. It's simply that she is a person who is associated with an adverse party by the plain text of the rule and by the statute, and that is why we are allowed to cross her, Your Honor.
Just one more thing on this, and then I'll be done, if I may.
Go ahead.
So I'm well aware of the rule that is cited by counsel, but just because she is a state of Iowa employee or that she may have been called as a witness by the state does not substantiate the claim that she is somehow identified with us. The medical examiner goes to great lengths to remain neutral in their opinions. She is not employed by the Attorney General's office. They are completely separate. I would go back a little bit of a history lesson in that the ME's office used to be part of the Department of Public Safety, and they were moved out of the Department of Public Safety into to Health and Human Services, formerly the Department of Public Health, for that reason, so that they can maintain their neutrality. She gave an opinion that we utilized at trial. They don't like it, and that's fine. But that does not mean that this rule has been, that the terms of this rule would allow them to ask the leading questions in the manner that counsel is claiming she can ask leading questions.
May I make one more point of record, Your Honor?
Go ahead.
I mean, the offer of proof that we'll make, which we can elicit from this witness on the stand, is that shortly before Mr. Mullis filed his post-conviction pleading in this case, my colleague, Ms. Neshawat, wrote a letter to the medical examiner's office directed to this witness, giving this witness information about new material in this case and asking to speak with this witness. And the records that we have reflect that this witness consulted with the Attorney General's office, consulted actually with counsel to my left, and from that conversation determined that it would be inappropriate to speak with Mr. Mullis's counsel, and so she did not. And that reflects that she is taking legal advice or, direction in this case from literally the attorney sitting to my left. She did not communicate with us. She is not a neutral party in this litigation. And she remains an employee of the state of Iowa, whose office is in the same building as the Department of Public Safety, who is an employee of the state of Iowa, whose work in this case was in the context as an employee of the state of Iowa. So that's exactly what this rule talks about. And the last thing I'll say about this, Your Honor, is were she not a person who could take legal advice and direction from Mr. Brown, and I do not say this to impugn Mr. Brown at all, it's inappropriate for an attorney in litigation under the rules of professional responsibility to advise a neutral witness not to speak with a party. That is one of the core rules of our profession, is that I cannot tell a witness, don't talk to the other side. The only way that it would be even appropriate for an attorney to do that is if that person can give that person legal advice because they are associated. And I certainly don't accuse Mr. Brown of having done anything improper. But the reason it was not improper for him to tell this witness not to speak to us is because they had a legal relationship. And so she's clearly identified with that party. If she wasn't, then there would be another issue that we'd be raising here in terms of professional responsibility, and we're not.
At this time, the state is not planning on calling her as a witness. Is that correct?
Your Honor, Dr. Kruse is listed as the state's expert witness and would be handled at the same time. To my knowledge, that would go to the court's pretrial ruling as it relates to the breadth of the testimony. I guess on the point of the breadth of this objection is, one, citing the rules of professional conduct in this aspect would seek to wrongly impugn an attorney's testimony here or an attorney's questioning here. There hasn't been, I believe, proof provided in this case, and perhaps I'd love to see it, that would suggest that there was some sort of impropriety. But beyond that, the deposition testimony that they sought to admit into the record already and sought stipulation to, for instance, regarding Dr. Kruse, they were, Mr. Mullis's counsel was completely comfortable asking open-ended questions there. and this sort of accusation would predate that. Again, we have extensively included in motions and resistances what the state means as a party here in this case, and this is just wasting the efforts. They certainly could ask about that in an open-fashioned way. Before this case proceeded, were you contacted by Mr. Mullis' counsel with new evidence? That can all speak to what Dr. Kruse did, but it certainly isn't shaping the purpose or why leading questions should be permitted here. And that is just too broad and too improper, Your Honor.
Obviously, this isn't as black and white as it normally is because this is a PCR. And there's already been the underlying criminal trial where some of these people have already testified as witnesses for the state. It's also not as black and white as it normally is because some of these people are employees of the state, albeit in different offices. And some of them have no other place to turn for questions than the AG's office. Looking not just at Dr. Kruse, but at the list of names that are included in the motion that was filed on February 3rd. Obviously, I assume there are some different arguments for some of these other people, but specifically with regard to Dr. Kruse, the responsibilities of the state medical examiner are dictated and directed by statute and rule. They're not controlled by or directed by the Office of the Attorney General. In the absence of some foundation or finding that the state in this matter was directing Dr. Kruse's investigation or autopsy, I don't think she falls under this rule. So I'm not going to allow leading at this point. And I think generally speaking, it's probably going to be the same with regard to the rest of these individuals. I am assuming that similarly, there probably has been communication between these individuals and counsel at various points, but they are from different agencies. And you're free, obviously, to make whatever arguments you need to individually, whatever record you wish, either now or when we get there, but that's where things stand for now.
I understand the court's ruling. I think, and again, we truly believed, and I say this only because I apologize for this coming up now, because it was truly the belief of every attorney for Mr. Mullis that this had been resolved at the pretrial conference, and that the reason we were agreeing to call her today was because we were going to be able to call her in our case and lead her. I understand the court's ruling. Respectfully, we disagree, but that's why we called her now. And I do think we need to confer briefly about what this means for us, because the appropriate examination for her, in our view, is this one. And if this isn't the examination the court is going to allow us to have, I think we need to decide whether we're going to have the state call her. So we need to make a determination about that, Your Honor.
Certainly. And we can, as I said, we'll take our lunch break at this time and plan on resuming at 1:15, and I'll be in chambers, so if there's anything that we need to talk about with regard to the schedule, you know where to find me.
Thank you, Your Honor.
Okay.
Your Honor, there's only one more issue that might be helpful
Sure.
to address while there's no witness on the stand. So just this morning, we were given a demonstrative exhibits for a witness that was initially identified earlier this morning that Mr. Mullis' counsel intended to call. These are demonstratives that were, to my knowledge, never provided to the state. 11 months ago, I believe, the state did discovery requests, as the court knows, specifically requesting copies of any demonstrative aids intended to be used by Mr. Mullis' counsel or any of their witnesses. We received those exhibits, or demonstratives rather, at 9:42 a.m. today. It was never produced in discovery, and I know Mr. Mullis replied, because I inquired while trial was ongoing, whether these demonstratives were provided in discovery, and the response was that they got them this morning from the witness. However, given the late disclosure of these demonstratives, I believe that it is improper, especially considering this was a subject of months of discovery in this case and has resulted in numerous other motions related to the destruction or disappearance or what have you of other demonstrative aids. So I think it is an unfairness to the state to have additional new demonstratives, including highly technical mathematical calculations in them, and we can show them to the court if that would aid in your ruling. But I believe any demonstratives that had not been produced in discovery prior to the start of trial would be improper and unfair. Thank you.
Did these demonstratives go with?
I believe it's with Dr. Hammers is the only one that we've been provided thus far.
Can I respond, Your Honor?
You may.
All right. What counsel's talking about are two photographs. The photographs are photos of Ms. Mullis from Autopsy, and they have some measurements on them that are pre-marked. Those measurements come directly from Dr. Kruse's notes that are on Exhibit 380, page 3. They are her measurements. This isn't something that is calculations. It's numbers. There's numbers written on a document that we intend to use with a witness. They're literally transposed from Dr. Kruse's notes. While a party is entitled to, make whatever interrogatory and document request they want in discovery, a party can't change the court's deadlines for providing materials by, asking for discovery that would require a party to anticipate, months and months, in this case, months and months and months before trial, every piece of paper they're going to show a witness at trial. There's not any new information here. It's literally a photo with numbers from Dr. Kruse pre-written on it. That's what it is. It's not a surprise. The idea of this being related to document destruction is, at that point doesn't make any sense. That's what this is. It's a photo with numbers from Dr. Kruse written on it. And we can lay the foundation for those numbers with Dr. Kruse.
And briefly, Your Honor, just to wrap this up, certainly I wasn't implying any document destruction was related to this. However, in reference to the counsel invoked the court's pretrial deadlines on giving exhibits, just this last Saturday afternoon, a day and a half before trial, we received a new exhibit that was never exchanged and never produced in discovery. And when I requested counsel specifically provide the day and time that it had been produced in discovery, no answer was given. So we would ask that the court put an end to the continuing production of new material and exclude evidence and materials that were not provided prior to the court's pre-trial deadline, which was 21 days before trial.
If somebody could please provide me with a copy of the demonstratives so I could take a look at it quickly over lunch, I will do so and let you know what we'll do with that. We'll see you back here at 1:15. Court's in recess until then.
Your Honor.